Hi everyone, I am Suyash and today I will talk about an interesting case in which a person sold a property that it did not own. I know that it is hard to believe this, that how can a person sell a property that it does not own? But imagine a situation where a person executes a power of attorney in favor of another person to rent out a property or mortgage it. But instead, the power of attorney holder sells that property without the permission of the actual owner. Is such a sale of property valid? This was the question that was answered by the Supreme Court in the recent case of Uma Devi Nambiar versus Tharma Reseri and others. And thankfully, according to the Supreme Court, such selling of property is not valid because it is a fundamental principle of law that no one can pass on a better title than what he himself has. In Latin, this is also called as nemo dat quod non habet. Basically, you cannot give a thing that isn't yours. And if you don't have any ownership of a property, then you cannot transfer it to others. Now, in the context of the present case, a power of attorney is simply a document that empowers a person to be an agent for a specified purpose, and such agent can do only those things that are expressly written in the power of attorney. If the power to sell a property has not been provided in it, then the agent cannot go ahead with the sale. To further explain this, let us take an example. Suppose you are buying a property that is being sold through a power of attorney holder. In such a situation, you must check that the instrument of power of attorney expressly authorizes the agent to sell the property and get such sale of property registered in accordance with law. If such express provision to sell is not present in the power of attorney, then it would be advisable to not to go ahead with the sale. Now, let us also understand the second reason as to why a person cannot sell a property that it does not own. It is because of Section 41 of the Transfer of Property Act that provides that any sale of a property by an agent or a person portraying himself as an owner will be valid only when the person who has purchased such property takes reasonable care to determine that the agent had express authorization to transfer the property. If the purchaser does not make honest efforts to ascertain the actual owner or the status of the property, then any such purchase of property made may be nullified by the courts. Here, by honest efforts or reasonable care, it is meant that the purchaser should read the text or the contents of the power of attorney very carefully and should see if all the papers of the property seem to be genuine or not. As later on, the purchaser cannot take an excuse that he did not know the law of the property or that he could not understand what was written in the documents showed to him. Basically, he cannot plead ignorance. Further, in such situations, if the matter travels to the court and the purchaser wants his money back from the agent, he must show that he was either misrepresented or cheated or deceived and was made to believe that the agent had the power to sell such property. Thus, we see that if a person sells a property that he does not own, or if a power of attorney holder sells a property that he is not authorized to sell, such sale of property is legally invalid. Essentially, one must remain cautious by examining all the documents relating to the property, and in case there is a power of attorney holder in between, it must be made sure that he is duly and expressly authorized to sell the property. So, I hope that the answer to the question as to why a person cannot sell a property that it does not own is clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like, subscribe, and comment. See you next time. Till then, stay tuned.